think the law is clear that what the legislature says, the legislature means. And I'm always interested when I see court opinions beginning to go way beyond what it says and trying to read other meanings into it, and including a Court of Appeals, Special Appeals decision, which has nothing to do with this case, on the definition of what a citizen is. I'll never forget that one. But anyway, let me go on. On the 23rd of July, 2009, the board approved an application and transfer of a license to 1218 East Cross Street. No hardship exception was ever requested. No transfer was ever completed. Article 2B, Section 504D, Baltimore City license expires, is the word that, not dead, but expires 180 days after the holder of that license has closed the business or has ceased active alcoholic beverage business operations unless hardships requested, pending, or approved. With respect to transfer, Article 2B, Section 10-503D, a transfer must be completed within 180 days. Of course, I'm quoting the legislature. If not complete within the time period, then the authorization lapses. The Attorney General's opinion that the 108-day statutory provisions is mandatory. It's clearly stated many times. June, I can't read the date, something 19, 2009, application to transfer ownership of the bar Turners to the new, this licensee, applicants, also the transfer or request for location change from 4 East Cross Street to South Charles Street. The board on July 23rd, 2009 approved the application and the transfer. 180 days starts to click. 180 days goes to January 19th, 2010. Then Mr. Sam Daniels, who was a member of our staff here at that time, put in some kind of a hearing or a meeting, granted a extension until July 25th, 2010 for transfer to be complete. Nothing happened until September 16th, 2010. The board gave another 60 days to November 15th, 2010, and nothing happened. This is on your transcript that I read, page 21. Protest in April 2011, not successful. Another renewal, again transfer on page 21, nothing happened. On August 18th, 2011, the board granted another 60 days. That makes it 276 days, and nothing happened. It wasn't told, according to what I was reading. The new 60 days goes to October 17th, 2011. The staff writes a letter on February 28th, 2012. You haven't paid. They write a letter to the licensee. The license is going to expire. You better pay. They paid, and another renewal was given. That's on transcript page 21. On May 2nd, 2012, the staff writes another letter. Didn't pay the license fee. Said the transfer was approved, supposed to be completed. You stated this process on July 2009. On transfer 22, it says the original location for the transfer was 1100 South Charles Street. The original LLC that was going to operate this restaurant was forfeited in its charter for failure to file some kind of property release. And this was on October 1st, 2012. It's one of those strange situations that's never explained later on in the record. The board granted another 60 days extension. Now we're at 395 days. No action. New date is January 14th, 2013. On February 2013, an application for transfer and expansion. The hearing was June 27, 2013, and the board denied the transfer. It was an appeal to the circuit court on validity issue. Board counsel said the board had not had a full discussion on the matter. It was a 5-hour hearing, and remanded it, and said that you have to have a result this month. And then here we are, says the board, on February 20th, 2014. The license The licensee had had the license for 1,673 days and for 3 years with no tolling, or 1,146 days of no tolling. Now comes the issue of estoppel. Estoppel is argued at this point, and it really is, I think we all agree, it just doesn't make sense. I don't know what they're talking about. On transcript page 35, says the board says they're renewing the license absent protest. And my question is how? The license is valid, and then they raise the issue of res judicata, and then the board says that doesn't make sense. The board decision of the hearing on February 20th, 2014. They were pondering estoppel, said the board. Does the acceptance of renewal fees preclude us, said the board, from declaring this license invalid as of today, meaning February 20th, 2014? Did the licensees detrimentally rely on perhaps promises we made, said the board, by accepting the renewal fees? And quoting directly, to avoid injustice to the license is to declare the license viable as of today. That was what the board's decision was. So basically, in order to avoid injustice, the board decides to renew the license. Thus, the board decided to balance the equities it determined existed without any factual findings, in total lack of regard to its binding laws. Then there is a legal memorandum filed by Mr. Woolman of res judicata, collateral estoppel on his page 5, Court of Appeals, where substantial evidence is the court accords deference to the administrative agency in its sphere. And I find that there's really no conflict of facts or anything that this would apply here. Following the stipulation of dismissal and agreement for remand from the Circuit Court of Baltimore City, the licensees finally filed a request for a hardship extension. This board stayed the motion until the issue of the validity of the license is resolved. On September 4th, 2014, I ruled that the issues, both the validity of the license and the hardship extension, should be consolidated and heard today. And here we are. In Miller versus State, 174-362, our 1938 case is quoted, Article 2B, Section 101B, 3, quoted saying, quote, the powers granted, and I'm directly quoting but leaving out certain words, the powers granted may not be construed to grant powers not otherwise granted, end of quote. So the code says it expires in 100 days after closure or ceased activity. The transfer must be completed in 180 days, which is exactly the Attorney General's decision. Again, the word shall means mandatory in Maryland. Express direction given by the legislature regarding the privileges, not right, of dispensing alcohol. The citizens are charged with knowledge of the law, and certainly the lawyers. Here in this case, there is nothing ambiguous of the facts. The clear command of the law is ignored, and on page 12, the action by the administrative agency, the liquor board, outside the scope of its authority, may not form the basis for equitable estoppel. Article 2B, the 180-day rule, within which a party must complete a transfer, is told only upon death, is pending, or it is filed within the 180-day period. Thus, acceptance of renewal does not toll the 180-day time period. The legislature in 2001, which was quoted in argument, considered giving the liquor board the power to grant extensions of license fees if are paid. Was not passed. That was Senate Bill 138, 2001. A government body cannot be stopped from enforcing the law by unauthorized actions of government employees. And again, the case of 366 Maryland 158 of 2001 was quoted. The licensee argues they weren't notified of the appeal. And I mentioned the council points out that 10 days after the decision was docketed in the circuit court, a letter dated April 9th, 2014, counsel for the licensees wrote Alderman, the chairman of the liquor board at that time, and acknowledged that the Federal Hill Neighborhood Association had filed an appeal in the circuit court. This matter is now before this board on the remand from the Circuit Court of Baltimore City for further consideration. Prior illegal, incorrect, inexplicable decisions place a duty upon an administrative agency to correct. Section D of Rule 8604 allows a remand for further proceedings in the interest of justice, nor should the liquor board try to correct mistakes, omissions, failures to act of the licensees by examining what is best for the licensee. The sale of liquor is a privilege, not a right. The license has expired for all the reasons stated above. My fellow commissioners, your positions.
I agree with Chairman Ward, and really for all of the reasons stated, and I can't state them any better or any more clearly.
I asked a few questions during this hearing and trying to get some clarity on the subject matter. And it's easy for us to sit here today and say, well, the last board, we can't justify our decisions by the last board. We as a body are charged with reviewing the law, listening to the information coming before us, and then we're making a sound decision. And that decision may differ from the last board. And sometimes presentation before the new board is slightly different from the presentation of the last board. My decision. I think that this case is one that is bigger than this body here. I think this case is one that should be before the circuit court, although it was remanded back to us. I don't agree that we as an agency did all the things we needed to do to convey to the licensee that you are responsible for whatever they were responsible for. We didn't make that clear to them. Yes, they do have a right to know the law that governs the vendors that they operate. Yes, if they don't, they should have some legal authority that they can go to get this information. But in real life, it doesn't happen that way. And I know we have laws to govern how we live and interact. And I always say, we need to deal with the intent of the law. And sometimes the intent is sometimes lost when you read the law. And we all have comprehension. We all can interpret things, but we don't always interpret the same thing. We have two learned lawyers before us, and neither can agree. We have 3 judges here. 2 of the judges say no. I say yes, that the license is dead, and I'm saying no. I think a second chance is needed.
And just to clarify the no's, we both voted no, and you're voting
yes.
Yes. Gentlemen, you have our decision.
Thank you, Your Honor.
Can I wouldn't be myself if I didn't respond to that. I just want to say, I do think that licensees are charged with understanding the law of liquor licenses, and they all have the opportunity to retain counsel if they wish. It's not required. In this case, the licensees have able counsel. They have a very, very good attorney. The size of the filings alone would attest to that. And I think that they've been well represented by counsel, irrespective of anything that the board did or didn't do, the previous board. They have an attorney who could advise them every step of the way. And I have to believe that the licensee's attorney informed them of the challenges that this case presents. I clearly agree with Judge Ward, Chairman Ward on this, and I don't want to go back over all of that, but this is not a case of confusion or lack of very, very good legal counsel for the licensee. There's no mystery here.
Folks, we'll stand in recess.